The only thing that restricts the activities of the surveillance state are policy. And because of that, a new leader will be elected. They'll flip the switch, say that because of the crisis, because of the dangers that we face in the world, some new and unpredicted threat, we need more authority. We need more power. And there will be nothing the people can do at that point to oppose it. And it'll be turnkey tyranny.
Ladies and gentlemen, thank you for joining us back here today. Today, we're going to have a law lesson and a lesson in administration. So let's just go ahead and jump right into it. Got my fizzy, my phone. Okay, time for comments of the day. Hank Matthews, Class D felony, 7 years. Your rhetoric and attitude is going to help her be separated from her daughter for a long time. Okay, here's JC Holmes' reply. And that's not me, it's somebody else. Exactly what part of what he is saying do you recognize as rhetoric? And how is giving someone the tools and path to fight a tyrannical system that has gone unchecked for 100 years going to help her be separated from her daughter for an extended period of time? Either you are okay with the status quo and have no qualms with selling out your fellow human beings, or, and I lean toward this one, you are somehow linked to or employed by a government agency. If you have a better way of doing it, we are all open to learn something new, if delivered in an intelligent fashion and can be verified, preferably back to our Supreme Court bound volumes. Thank you for sharing your view. And then Matthew Grubbs. Wow, because that seems like law, doesn't it, Hank? I wonder if you would think the same if you were in Angela's shoes. So, and I'm really proud of these individuals because they're not fighting, they're not being aggressive, they're just saying, hey, there's a problem, have you thought about it from the other side? And if you have a better solution, Hank, we would all love to hear about it. We'd all love to hear about it. Otherwise, if you're not part of the solution, you're part of the problem. And you're part of the problem because you don't know law. Okay? Which brings me to my next favorite comment. And this is by Throwaway. And I'm not going to read the whole thing because, it's kind of silly. But it says down here at the bottom, I have probable cause to believe you are incompetent. I am incompetent. Ha! Ha! Well, you know what? That actually might mean something if any of y'all knew what probable cause meant or what law was. But my mom always said, sticks and stones can break my bones, but words will never hurt me. So here we go. Section 15 of your Constitution in Missouri. Because, when I was messing with North Carolina, I showed them in their own code and their own statutes where they abolished law in history. When I was talking about Georgia, I showed how in their law, how the jury trials put together. When I was messing with the judge up in Kansas, I showed in their law the difference between a statutory action and common law action. So just because this is Missouri, and this is the problem, and this is the issue right here, I'm going to show in your law. Just because that's what I do. This is who I be. So, here's what your law is. And then I'm going to show you your administration. Section 15 of Article 1, and this is your Declaration of Rights. Unreasonable search and seizures prohibited. And of course, it has language very much like the Fourth Amendment. And down here it says, no warrant to search any place or seize any person or thing or access electronic data or communication shall issue without describing the place to be searched or the persons or things to be seized or the data or communications to be accessed as nearly as may be, nor without probable cause supported by written oath or affirmation. Okay, they actually put written oath or affirmation in here. See, back in the day, not everybody knew how to read and write, so you would just go in and you would verify. You would verify viva voce of the living voice. Of the living voice, because you're living. Okay? This stuff is not living, it's not real. You're real. All right. So, right there, that's what you got. Now, let's move to the part of the Constitution that gives the judicial branch any type of authority. See, they authored this Constitution, and it gives them the authority because they author it, and now they're carrying it out. Why? The act of doing. Okay, Section 5, Rules of Practice and Procedure. A duty of Supreme Court, power of Legislature. The Supreme Court may establish rules relating to practice, procedure, and pleading for all courts and administrative tribunals, which shall have the force and effect of law. It shall have the force and effect of law. Do you know what that means? That means it's not actually law. That's what it means. It means it's going to have the force and effect of law. It's quasi-law. It just appears to be law, but it's not. That's why it's administration. Okay? Now, I know that that's kind of, okay, you're skating on thin ice right there. All right, so let's just go to Section 18 of the same judicial part of the Constitution. Judicial review of action of administrative agencies, scope of review. This is interesting. All final decisions, findings, rulings, and orders on an administrative officer or body existing under the Constitution or by law which are judicial or quasi-judicial and affect private rights shall be subject to direct review by the courts as provided by law. And such review shall include the determination whether the same are authorized by law. That's really interesting. You see, because what did it just say? It said judicial decisions that are made administratively. Well, you can't really do that because judicial officers are judicial officers and they're bound in law. So any decision that they make is bound in law. But it said judicial or quasi-judicial. Because quasi-judicial is administrative because it's not judicial. It just appears to be judicial. It just gives the illusion of being judicial. Okay, and this is how it's set up. And it's set up like this in every single state across the country because this is how they get warrants to arrest people without having a verified complaint from the wrongdoer. This is why so many people get arrested for drugs. This is why people get arrested for child support, for anything administrative. Is because of this setup right here. And unless they know how to challenge it judicially, they get ran over, punked, screwed. It's awful. And most people don't have the education to challenge it, which is why I do what I do. Okay? But here's the thing is that I've been doing this for a long time, and now I'm getting scared like no other time in my life before. I've done some crazy stuff. And I'm getting scared because they're just not doing law no more. They're just not doing law. They're just going full out administration. Because nobody sees it. Nobody sees it. Nobody's doing anything. Nobody's doing anything. You want to know what would have happened 120 years ago? That happened in the streets. Everybody would have come out and gone click clack. That's what would have happened. Nobody in society would have put up with that. 120 years ago, a government official came and said that they were going to take your kids with a piece of paper. Oh, yeah. Hope that paper's bulletproof. And everybody would have been in on it because they know if the government can come and do it to their neighbor, they can come and do it to them. See, and also they had this thing called the Creator in their heart. Because if you go and look, the Bible says multiple times, God's talking about, I put the law in your heart. So, how does this relate to Angela? Well, it's really kind of simple because, you see, she had the felony, right? They issued the complaint, and right here are the procedure applicables to felonies only. And this is from the Missouri courts. The Supreme Court wrote this up. So I guess it just has the appearance and effect of law. It's not actually law. And right here, where they're talking about how the complaint shall be made, it says, signed by an attorney on information and belief. All they have to do is believe that there was a crime committed. And information is just like, I could tell you something. It couldn't even be true, but it's still information. Okay? So then when you're talking about the statement of probable cause, right here it says, okay, F, be signed on a form bearing notice that false statements made therein are punishable by law. Okay, well, it wasn't saying, notice what it was saying is that they know, that they're aware false statements are punishable by law. But that's not swearing or affirming. And there's a very particular reason why they do this, okay? And I'm going to break it down to you like this. When Alex Acosta let Jeffrey Epstein walk, or when Greg Newman let a child rapist walk in North Carolina, you see, they couldn't do that. Like, the judge couldn't be okay with that or allow it to happen if there were facts upon the record of the court, because the only thing that can challenge or change facts upon the record of the court is a jury. And this is why if you have some type of crime that's perpetrated against you and you go down to the police station, they're going to investigate. They're not going to put you on the witness stand. They're going to have an officer investigate, and the officer is going to go on the witness stand, and the officer is going to tell the court a bunch of hearsay because they don't have any firsthand knowledge of the facts. All they have is what you told them. And, well, they can control the whole thing. They can just lie. Yeah, they can just lie. They do. All the time. And that's administration. That's administration. And that's why real criminals get to walk, and then they go put a black man or brown person in prison for a gram of cocaine like it's a real crime when it's not. That's why they can just come take your children. This is what's really going on. Wake up. Wake up. Anyways, I'll play a little video of Connie Regula. I don't know how to pronounce her last name because I'm horrible at that kind of stuff. Let's just say that all the stuff against Angela is true. Let's just say it's true. Is it really worth putting somebody in prison for 7 years for saying there are consequences to your actions? Because the only reason that would feel harassing to you or threatening to you is because you did something wrong and have a guilty conscience? I mean, if somebody told me that there would be consequences to my actions about this stuff, I would say, I hope to God there is. I pray to God there is. I pray to the creator of all things that there are consequences, like everybody listening, like everybody getting together and doing something about it. I definitely wouldn't feel threatened. It's going to go on as long as society allows it to go on. I know how to fix it, but I feel like I'm screaming, nobody's listening. Anyways, I appreciate all the people who do listen, all the people who do follow, comment, stick up for doing the right thing, all the people who understand the Creator because the Creator talks to them in their heart. Thank you. And we are Just Conspiracy, and we wish to conspire with all other good people of this planet to leave a better world for future generations than the world we all grew up in. One world, love, and peace.
No, we had so many jury trials going during that time, and that's not true. I again was relying on memory. It was Superior Court, but administrative court, not jury trials. I just finished a jury trial in Polk County. We were preparing for another term. We had a lot of jury trials in all three of our counties, and so I just sort of had jury trials on the mind, I guess. But it was administrative court, not a jury trial. You're right.
At any rate, there was no jury trial underway.
That's correct. It was administrative superior, not jury trial superior. That's right.
And you said our file shows that the mother never returned our call. Your file doesn't show anything with respect to that.
Well, the file does not show that. The file doesn't show that I made the call. The file doesn't show that she called back.
That's what you told the State Bar, was that the file shows that the mother never returned our call. So
Right.
we were assuming there'd be some documentation in the file that the call was not returned, and there was nothing in there.
I knew from the file before that there were notes there inside the file, and I was remembering that maybe there was some notation made there, but I was incorrect. You're right.
But she hadn't looked at the file. We're answering this.
I don't think I did, Mr. Murphy. I think you're right. I don't think that I did.
Just to make sure that everybody plays by the rules. Because we have a set of rules like any other, game, baseball game. You play by the rules, whatever they are. And you don't go on play a baseball game and use football rules. Or have no rules. So that's part of my function, and justice and fairness flows both ways. You have one party following the rules and another one that doesn't. And the one that doesn't is saying, well, it's because they didn't know what the rules were.
She agreed to that she would review it, so.
I don't know what that's going to do, though. Again, I mean, and you're correct in that if they were to come back, you'd have to subpoena them. Jason is an attorney. I'm sure he'd have to send witness fees. He probably doesn't even know how to do that, And the only way for continuance to be granted is, for this OP to remain in place, which and extended. So I don't know.
You understand that, right?
Yeah, so that's how important it is.
We're saying that the OP would still be in effect until we get this. Is there anything in the petition with respect to what happened at mediation?
Well, not with regard to what happened on March 9th, which I believe that's the day he's referring to, because that was the day after the EOP was. The testimony from them was there's not anything that specific regarding the petition.
She opened that door, like I said, and brought him in there.
That was all after the petition was filed, isn't that?
Some of Natalie's testimony was with regard to before the EOP was communication with, try to get mediation set up.
Yeah, I mean, they only met me for 20, 30 minutes, and I mean, they're making some crazy remarks and basically saying that I shouldn't be a father. And I said, this recording will definitely show you different. Heck, they even offered me a beverage.
I think it might have some bearing on this. And so I reluctantly will grant a continuance for you to get them.
Okay. This is how you know it's all administration. What you just heard right there was a man standing in court arguing against an attorney. The attorney had a GAL, a guardian ad litem, come in and testify against this man and commit perjury upon the record of the court, along with his wife and his paralegal. And what this man was saying was, I'm going to have to call him back because I got video evidence that they committed perjury. I'm going to have to put him back up on the stand. And before this little clip was taken, the attorney, they were arguing for like half an hour. The attorney's like, well, that's against procedure. That's against judicial procedure that the Supreme Court wrote. You can't do it. What did the judge do? He said reluctantly, do you think that judge really wished to postpone this and call an attorney back and his family and his paralegal when they're being accused of perjury? No. But that's the law. That's the law. I'll have more on this case later.